Good morning, ladies and gentlemen. On behalf of the German presidency and on behalf of the Commissioner for Justice, I welcome you to this event, to our discussion on digitalization of justice. We are living in difficult times. Germany is facing a new and very hard lockdown, and I'm very sure that almost every other country in the EU is facing the same situation. But nevertheless, I think it's a good time to talk about digitalization because, in my view, the pandemic has shown us how important it is to be able to communicate virtually. You can see it by the way we are discussing today. And you can take a look at one other example, the German Federal Court of Justice, the court where I am working, didn't have any equipment for video conferencing by the beginning of the pandemic. This has changed. I don't know how I could do without video conferencing, and I'm pretty sure we will keep this equipment even when, what we all hope, when the pandemic is over one day, perhaps in the next year. So I think the pandemic has one good side. It has given a tremendous boost to digitalization. There is still a lot of work to do, and therefore, as I said, it is a good moment to talk and to discuss about digitalization of justice. There's another reason why it is a good moment to talk about it, and this is the communication by the Commission to the Parliament on this subject, which has been published on the 2nd of December, some 2 weeks ago. And I am very glad and very proud that this event is hosted by the Commissioner for Justice, by Mr. Reynders, who will discuss with us on all these topics and will open this session by giving us a keynote address. Commissioner, welcome to the event. Thank you very much for being here. The floor is yours.
Thank you very much, Mr. Bacher. And ladies and gentlemen, I'm delighted to welcome you all today for a virtual roundtable. Earlier this month, you know that the Commission has taken an important step towards justice going digital with its new communication on the digitalization of justice in the European Union. Our communication is only a point of departure, and my primary intent today is to listen and learn about the practical needs and challenges you are facing in the switch to and the use of digital tools. And I know, like you said, Mr. Bacher, that it was very useful to have digital tools during the pandemic, and I know that we are in a very difficult second wave, and it's very important to continue to think about the best use of digital tools during such a kind of situation. And therefore, I would like to quick start the discussion on this important topic, which I'm sure will be the first of many to follow. At the EU level alone, we have been working on e-justice for more than a decade now. However, we can and we must do more to exploit the achievements of digitalization of justice. At the same time, we shouldn't forget that digitalization is not an objective in itself, but a means to an end. That end should be efficiency, accessibility, and resilience of justice systems by swiftly taking them forward into Europe's digital decade. And I'm hoping that it will be possible to show in the next justice scoreboards in the next years that we have a real improvement also due to the use of digital tools in the justice system. So our citizens and businesses need and expect swift and efficient tools to be able to enjoy seamless access to justice regardless of where they reside. Legal professionals can also greatly benefit from the ability to work remotely and communicate electronically with counterparts within and beyond national borders. Digitalization allows greater transparency and helps us build mutual trust. And you know that trust is the key word between the judicial systems in Europe, between the member states, but also between the citizens and the authorities, and certainly between the citizens and the judicial systems. Despite broad political support and significant tangible progress, we are not quite where the EU and its member states need to be to serve our citizens and businesses. A mapping prepared by the Commission on the digitalization of justice in the member states clearly illustrates this point. I've presented to the Minister of Justice in the last Justice Council, and in a number of member states, progress is evident. However, there is more to be done. In only 10 member states, individuals can access an electronic file of their ongoing cases in all types of civil law procedures. In only 13 member states, evidence exclusively in digital format can be submitted to a court in the context of all types of criminal proceedings. And in just 10 member states, in civil and commercial law, digital evidence is admissible in all types of proceedings. Legal professionals, our citizens, our businesses, all deserve better. Like many other sectors, member state justice systems were adversely affected by the current health crisis. Citizens and businesses suffered the ill effects of the pandemic by delayed access to justice. But despite its heavy economic and societal costs, the COVID crisis has also served as a stress test, a real resilience test for all the different sectors, but certainly for the justice system. And it has taught us an important lesson. The pandemic helped us realize that resilient justice systems are one of the mainstays of justice and of sustainable rule of law. That is why the Commission calls for renewed vigor for the digital transformation of justice systems. But we should be cautious not to fall into the traps of technocratic thinking. While digitalization solves most of connectivity and physical access issues, it can and does raise a new set of problems. How do we ensure equal treatment of disadvantaged users? How do we guarantee an appropriate level of IT security? Don't we risk excluding citizens who don't have access to the internet? Are we careful enough not to infringe on fundamental rights? I would like to focus here on a few topics I consider particularly important, and certainly the possible breach of the fundamental rights. We have received this morning a very useful report from the Fundamental Rights Agency about the possible violations of the fundamental rights with the use of AI in different sectors, but certainly also in the justice system. The first element that I want to insist on is the advent of artificial intelligence-based applications. Some member states already use such solutions in the justice field. For example, automated anonymization of personal data, machine translations, and text-to-speech. Such use of AI-powered applications can indeed save time, money, and labor. They are also of relatively low risk. Yet there are serious concerns where using AI, for example, for automated decision-making or for predictive justice purpose. There is a very important difference between the different kind of use of AI, also in the justice system. It's very difficult to say that we have a risk-based analysis sector by sector. We need also to go in more details about the different applications used in the different sectors, and certainly also in the justice system. Their appropriate safeguards are necessary as it can challenge the independence of the judiciary and infringe on fundamental rights. The Commission elaborated such aspects in detail in the white paper on artificial intelligence in February this year, just at the beginning of the pandemic. And discussions on how to regulate the use of AI applications that pose a risk in general to fundamental rights are ongoing in the Commission. we intend to present a legislative proposal in the first quarter of next year. My second issue is about how we enable legal practitioners to reap the full benefits of digitalization. The professional need to have the necessary digital skills, including knowledge of how AI applications work. Our recently adopted European judicial training strategy acknowledges these needs and serves as an important flanking measure to the digitalization effort. And we need to be sure that it's possible to train, first of all, the judges and the prosecutors, because it's our priority, that they are our priorities. But we need also to be sure that it's possible for all the professionals to receive a real training to be able to use digital tools and to understand what are the advantages of the digital tools, but what are, again, also the risks. And my third and last point is about cross-border proceedings in civil and criminal matters. Over the years, judicial cooperation has largely improved in the European Union. In criminal matters, the open arrest warrant is a success story, representing a significant improvement of extraditions. In civil and commercial matters, the open small claims procedures has helped many citizens with cross-border debt recovery. Still, our EU judicial cooperation instruments face practical challenges, preventing them from reaching their full potential. Paper-based exchanges are still the norm today. At the same time, voluntary attempts to transition to the digital channel are also prone to slow or limited uptake. For instance, the implementation of the online application of the open small claims and payment order procedures remains limited to just a few member states. Due to admissibility requirements and despite the possibility to exchange documents digitally, paper submissions may still be legally required. Electronic identities and signatures are not necessarily acceptable or recognizable across borders. In this regard, the opportunities for electronic identification and trust services provided by the regulation on electronic identification and trust services for electronic transactions in the internal market should be fully harnessed. Very recently, the co-legislators adopted the new regulations on service of documents and taking of evidence in civil and criminal and commercial matters. Most, if not all, of the EU civil and criminal judicial cooperation legal acts can certainly benefit from a similar upgrade. It should take seconds instead of days to send and receive a European arrest warrant or a small claims request. In the context of cross-border criminal and terrorism investigations, very often time is of the essence. Therefore, we are working on an initiative to make the default communication channel between competent authorities the digital one. We will launch a broad public consultation soon to allow all stakeholders to make their views heard. Ladies and gentlemen, I hope that you share my enthusiasm to launch with you today the debate on the justice systems of tomorrow. And again, it's very important that we have more and more tools to exchange between judicial systems and to exchange between the authorities by digital means. It's very important also to give the opportunity to all the citizens and the businesses to have a better access to justice with digital tools. Of course, we must be and remain vigilant about the people without such a kind of access. So it must be possible for the citizens and maybe for some businesses to have an access by other means. But between the authorities, between the judicial system, it must be possible to organize a real exchange of data on such a basis with digital tools. It must be the system by default. Among us today, we have several participants who I hope will share their valuable experience in this regard. And I want just to say that we have started this mandate in the Commission with, on one side, a Green Deal, but on the other side, the digital transition. And I'm sure, like you have said, Mr. Bakker, that there is the pandemic that we are confronting with it's very important to continue to work on it because it was very clear before the pandemic. It's maybe more clear during, and I'm sure later after the pandemic, that we need more and more investment in the digital tools. And to conclude, I want to say that is more for the member states, that we have insisted on the fact that it will be important for the member states to put emphasis on the digitalization of the public services, including in particular justice system, in their recovery plan, because it will be possible to receive some co-financing from the member states, of course, but also from the different facilities at the EU level, if we receive the recovery plan with, as a part of such a plan, the digitalization of the justice system. Thanks again, and I wish you, of course, many fruitful exchanges today on such a very promising topic. Thank you.
Thank you very much, Commissioner. There's a lot of work, but I think it's good to start the debate today, and it's a good thing that the Commission takes the initiative. We will have two sessions today, one dealing with legislative questions, the other dealing with AI tools and practical experiences in using AI tools. We will start with legislative questions, and each of these sessions will consist of 3 panels, 3 questions, which will be addressed by 3 different panels with practitioners from many member states. I will introduce them briefly to you, and then they will give their address. And after each question, the Commissioner will have the opportunity to give his own comments and to add his own thoughts on these questions. Let's start with our first session and with our first question, and it's about the priorities. Where should be the priorities in bringing Europe up to speed with digital proceedings, and what aspects of digitalization should be prioritized for funding? We heard that means are available. Now, which should be funded first, which should be funded as a priority? We will have 4 panelists dealing with this question. The first one is Mrs. Sabine Matejka from Austria. She is the president of the District Court of Floridsdorf, which is a district of Vienna, as far as I know, and she's the president of the Austrian Association of Judges. We will hear Mr. James McGill. He is, as I learned, vice president of the Council of Bars and Law Societies of Europe, CCBE. We will talk with Mrs. Simona Franguloiu from Romania. She is the deputy director of the Directorate for International Law and Judicial Cooperation in the Romanian Ministry of Justice. And we will hear Dr. Adam Todt from Hungary. He's the president of the Hungarian Chamber of Civil Law Notaries, and he's the vice president of the Council of the Notariates of the European Union. Now, where do you see the priorities and which aspects should be prioritized for funding? Mrs. Matejka.
Well, hello. Currently, we are exchanging many documents still in paper, and they're sent by post services. So this takes a lot of time for the administration, time for delivery, and of course it produces costs. So I think that the use of digital communication tools would have a very positive impact. If tools like, for example, the e-CODEX system become a standard application and really is used by all of the member states, for serving of documents, for example, or for the requests for taking evidence, so that all the forms and the documents can be submitted digitally and in a secure way. This would save us a lot of time, and it would save costs, of course, and it would make a cross-border judicial cooperation much easier for everybody. This is not only true for criminal proceedings and investigations, but it is especially important also for civil procedures too. I would like to emphasize that. The number of civil cases with some kind of cross-border aspect is growing really fast. There is a wide range of cases, including disputes out of business relations, as well as family law cases. So due to the open market and the mobility of EU citizens, We receive many requests from other courts in other EU countries for judicial cooperation. And cross-border cooperation between the courts is really getting more and more important. So having tools, digital tools to speed up such proceedings and making them easier for everybody on both sides, that would be very helpful for the judiciary. And this does not only include digital communication, but also machine translation tools would be very useful in that context. I think there is a strong need for such tools, and that every member state should be assisted to take part and use such tools, like, for example, e-CODEX. And one more priority, I think, could be the use of video conference systems. They turned out to be very useful now, of course, now under the COVID-19 crisis. But I'm quite sure that the extended use of video conference systems will stay even after the crisis, on the national level as well as in cross-border judicial cooperation. But however, we are still facing problems. And it takes a lot of time and efforts to solve technical problems when we have cross-border video conferencing. So maybe common standards would be very helpful. And there is also a need, I think, for funding in some countries to facilitate or further facilitate the courts with video conference systems.
Thank you very much. Now let's hear the lawyers. Mr. McGill.
Good morning, Klaus. I hope you can hear me.
Yes.
Good morning, Commissioner. We're very, very happy to have this opportunity of giving a practitioner's perspective from more than 1 million European lawyers, but representing millions and millions of clients. I think the first priority we would emphasize is that this progress must be available to everybody and not simply to commercial cases and state cases. And as Sabine has just said, family law is a good example of where people have unmet legal needs that can be supported by digital technology. We have found in the last difficult year that access to justice was only available by the use of digital technology. Clients could access their lawyers that way, lawyers could access the courts. So the time is absolutely opportune to capitalize on that positive experience. We've all been surprised how well we've coped. Our clients have been surprised how well they've embraced the technology, and this is the time to deal with this. So number one priority is to make this available to everyone. The second priority, and as is reflected in the communication of the 2nd of December, is to ensure that progress does not undermine Article 47 rights. So we need to show to the populace that there is integrity, confidentiality, privacy, and that can be supported by the webinars that are proposed, expert groups, and the CCB will be very happy to participate to bring practitioners' experience of where there will be shortcomings and problems. So priority number one is to make it available to everyone. Priority number two is to support integrity. We are very happy that the e-CODEX project will be the gold standard, and we will continue to play our role in that because it is a good project and it can be made even better with the project management proposal that is in place. Commissioner, I would ask you to look at some of the very good measures that are already in place, but have not been used properly. I'm thinking on the criminal law side with the investigation order and the supervision order that are really underutilized. And the new familiarity with digital technology gives us a great opportunity now to look at those existing measures as a way of reducing the risk to public health of moving prisoners unnecessarily for investigation purposes, or taking people out of their home states when they could be, their sentence could be managed in those states. That has not happened adequately, but digital technology will be the way forward for that. In terms of where the funding should go, Klaus, obviously the courts must be adequately resourced in terms of technological support and adequate numbers of properly trained personnel. So the personnel is key to this. But there's no point in having well-resourced courts if the lawyers aren't supported and trained into accessing it. So there must be publicly funded training made available to lawyers, particularly lawyers representing vulnerable or indigent clients. And Commissioner, you'll understand why we are a little bit frustrated with this repeated reference to training judges and prosecutors. There are more actors in the criminal justice field and in the justice field generally than judges and prosecutors. So lawyers who have the responsibility of protecting individual clients and safeguarding their charter rights must be given the support and the training. So they're my points, Klaus.
Thank you very much. This is a very clear agenda. Now let's move on to Romania, to Mrs. Franguloyo, who has just turned on her camera. Thank you very much, and please give us your view.
Thank you. First of all, I believe that regardless of the development of artificial intelligence, the justice system must remain centered on human person. So some measures have already efficiency in civil and commercial area, but I believe the impact of artificial intelligence is greater in the criminal field than in the civil one, because, for example, more than half of all investigations include a cross-border access request to the evidence. For that reason, I think we need the update of the evidence package. For example, to this day, the most recent example of mutual recognition instrument is the European Investigation Order Directive, which allows law enforcement authorities from one member state to request the execution of investigatory measures from the authority of a second member state, including, among others, the production and preservation of the evidence. So, in these cases, we need to preserve the validity of the evidence. So, the evidence still remains valid in all member states. This is not the only one. For example, currently, two models coexist for accessing the evidence across border. We talk about mutual legal assistance and direct cooperation with service providers. So I believe that the paradigm shifts towards a new order where direct cooperation between law enforcement and service providers begins to become the new standard. It can be achieved through a common effort in balancing the need to investigate crimes with upholding the fundamental rights and liberty, especially to a fair trial, and equally the victim's right. So, we have a big necessity. We need European Union internal rules for e-evidence access. I understand these are already prepared. We talk about one highlight. Traditional rules need to be adapted to digital environment. We have the preservation of evidence. We talk about the role of the forensic lab, and we talk about secure transmission. And not finally, we talk about authenticity and integrity of the evidence, and all of this always under judicial control. For now, talking about artificial intelligence and this application in the justice sector, we need all practitioners, judges, prosecutors, lawyers, and all judicial system staff. We need e-transcription, automatically transcribing records of oral hearing. We talk about e-translation, and maybe it's possible optical character recognition, maybe supporting the analysis and evaluation of legal documents and court judgments. and estimating the chances of a success of a lawsuit. This is for productive justice. I think the lawyers will be happy for it. And of course, automatically anonymizing case law or providing information via legal chatbot. I think these are priorities right now, but not finally. I believe that sufficient safeguards are needed to guarantee the protection of fundamental rights and freedom and to ensure a responsible, trustworthy, public interest-oriented, and human-centric development and use of artificial intelligence applications in the justice sector. Thank you.
Thank you very much. We have identified a lot of fields where action should be taken, and I'm pretty sure we will hear about more fields of action where action should be taken by the notaries, by Dr. Todd. The floor is yours.
Thank you very much. The CNUE is convinced that the use of new technologies can contribute to offer better service to citizens. For example, on the field of company law, incorporation of companies online and meetings with them by video conference. But we would request also the digitalization of the European payment order and also the interoperable electronic signature to be able to check the deeds that were made on abroad, whether they are real or not. Citizens and businesses should have a simple, resilient and effective access to justice, and the notaries of Europe support this approach. Notaries all over Europe are actively developing technologies to simplify the secure communication between the notaries, public registers and clients via electronic channel, and to provide their clients with effective solutions for the archiving of their documents for a smooth and secure access to documents. Notarial activity is more and more linked to cross-border context. It would also be useful to reflect on concrete tools which would assist the notarial activity cross-border and, for example, checking the validity of documents, as I mentioned before. I would like to remark here the new German system on the checking of power of attorneys, which is based on blockchain and innovative technology. Co-funding is very important in this context, and secure technical solutions are often very costly. At the same time, it has to be guaranteed that legal certainty and the equality of preventive legality control within the justice system, as well as the reliability of public registers, such as business registers and or land registers, will not be impaired by an enhanced digitalization of cross-border cooperation. Trust and legal certainty and effective protection of personal data have to be transported to digital world. The question of control of the technical solution is also crucial. As public officials, notaries manage sensitive data in their daily activity. Data protection, confidentiality, and high security standards in the digital world must be guaranteed in the same way than in the physical world. At the same time, the notarial profession close to the citizens insist on the importance not to exclude citizens who do not have internet access and make sure that these people will also continue to benefit from an efficient access to justice. The CNUE calls on the European Commission to favor the approach of interoperability between national systems rather than building complex European systems in governance, and maintenance. Thank you very much.
Thank you very much, Dr. Todd, and thank you very much to all the panelists for giving us such a broad and interesting overview of the many, many tasks which lie ahead of us. Now it's time for the Commissioner to give his first comment. I'm pretty sure he could talk for about some hours on all these subjects, but the time which remains is about 2 or 3 minutes. Just give us some of your most important thoughts.
Maybe just some remarks. I don't want to repeat what I said. This is my mistake here. If I explain maybe what is possible to do in many fields. But first of all, it's of course a national competence to decide about the way forward. But we try to organize a process with, first of all, I said a mapping of the situation and to explain that there may be best practices in some member states. It is possible to take into account the best practices to make progresses. But at the beginning, it's a national competence and sovereignty to decide about the way forward. But we have put in our first rule of law annual report many comments about the evolution of the digitalization of justice in the different member states. And again, I said we try to see if it's possible to receive some proposals about new investment in the recovery plan. Maybe another remark is about the cross-border evolution, because we need to organize a better use of digital tools, I said, and it was said also by different panelists about the cross-border activities. And certainly we will continue to work with e-CODEX. We transfer the management of e-CODEX to EU-LISA, the agency specialized in digital tools. It will be in 2023 that it will be transferred. And we are looking for new investment. Just to give an idea, in EU-LISA, so the agency in charge of IT investment for first the law enforcement authorities, we have, with e-CODEX inside, we'll have only 5% of the total dedicated to justice. 95 is going to law enforcement authorities, and it's so nice, but we need to improve that, and certainly to improve also different kind of instruments like e-evidence. I want to say to Mrs. Simona that, of course, in e-evidence, it will be a good example about the discussion for a balanced solution between the fundamental rights and a better prosecution and a better investigation first and maybe prosecutions. It's the same for the interoperability. I want to confirm to Mr. Todd that we are aware that we need to work on interoperability and not to build too much different new systems at the EU level. To give an example, we have organized such a way about the tracing apps, about the health situation. We didn't want to have an app at the EU level, but to organize the interoperability about among the different tracing apps is the same for e-signature, to have a better access to that. And we need to be sure that it's possible to have a real trust in all those exchange of data between member states. And about the registers for the notaries, I've said also to the notaries some days ago that it's very important to be sure about the way to proceed to organize the registers at the national level, but to exchange some elements between different member states. And of course, we want to avoid, if there are some use of AI, to give an example, again, some black boxes in such an AI. And I want just to insist again on the training to conclude, because I'm fully aware of the request from the lawyers and Mr. McGill, you said that it's not just judges and prosecutors, of course, but it's my first responsibility to go to the judge, the prosecutors, and the staffs in the courts and the prosecution office. But I want to insist, I've said that to the notaries, that our goal is to train 30% of the notaries on a yearly basis from 2024, but EU law, maybe also about the new digital tools, and to do the same for 15% of the lawyers. So we are very dedicated to train also the lawyers with the GTN, the network at the EU level. And of course, it's possible to propose some project because we have around 16 million to organize trainings, and a very large part of it is going to the GTN. But no, thanks again for the remarks, and we have taken note of different remarks that you have put on the table. But it's true that we want to work with the national level and not to build a real very important organization on IT at the EU level. The interoperability is very fundamental for all the different actors in the justice system.
Thank you very much, Commissioner, for this very deep and comprehensive information. I think every stakeholder can be sure they are heard and they're interested and their interests will be considered. We will focus on the subject of AI and on safeguards, necessary safeguards, which should be used to avoid bias and to ensure fundamental rights. In our next panel, it's about the key opportunities and the challenges in the use of AI. And as I said, it's about the safeguards which should be used to avoid these possible negative consequences. We will have 3 panelists dealing with this question. The first one is Mr. Bart Willox from Belgium. He's the president of the Court of First Instance in Antwerp, and he's a member of the Belgian College for Courts and Tribunals. Then we have with us Mr. João Paulo Raposo. He's the head of the cabinet of the president of the Supreme Court of Portugal, and he coordinates the digital transition process of that court, which, as I'm a Supreme Court judge too, it's a very challenging task. And we have Mr. Patrick Zanino from Paris. He's the president of the European Bailiffs Foundation. So he represents another group of very important stakeholders in this area. Now, what about the key opportunities and what about safeguards in regards of AI? Mr. Wilcox.
Thank you very much. You can hear me? Okay. Thank you for organizing this roundtable about a very important issue. I was asked, due to my role in the initiatives we took in Belgium to cope with the COVID crisis. So I'm not a specialist in IA, but yeah, we use it and it's very important. So instead of a number of colleagues, I don't want to be negative about AI at all. It's already there. So to deny it. And it's, I hear police calling, but it's not here. I don't know. No problem. Its influence of AI will increase each year, and as tribunals and courts, we should embrace it for the chances it gives, but as well being aware for its risks. Speaking about the chances, I think at most about our system that suffers of a lack of resources in combination with a huge lack of about the access to justice. We can't beat this just by digitalizing our old procedures, but we will have to modernize them, and then AI gives important opportunities, especially in the prevention and the reducing of conflicts before it comes to a classic procedure. I think it can be very important, but it also can allow to make better choices and mobilizing better the resources in the classic procedures. Opportunities, but of course also risks and challenges. Lots of questions raised about which data that are used, their selection, the numbers, representativity, the processing of data, the design, and the implementation choices. One of the priorities in this area, and that's for me the most important, we need legal initiatives like we heard that are taken by the EU, should be the formation of lawyers and judges in the assessment of the validity of algorithm. They will have to learn, not all at the same level, how to understand algorithms, the system behind it, to write them and to interpret them. An application of Article 6 of the European Convention on Human Rights, a fair trial, and the principle of contradiction, the judges will have to be able to analyze and to have insight in algorithms when they are used in a legal procedure. It needs transparency. And AI can assist us, but not in a blind way. And so this formation is very important. We will have to be aware at this field that not to replace inaccessibility and incomprehensibility of law text by inaccessibility and incomprehensibility of algorithms. We'll have to be creative how we can reconcile our fundamentals, our rule of law, with a complete different element in our jurisprudence as AI. To finish, the question of the bias. There is a lot of literature about this huge issue. It will have to be a permanent ambition to cope with bias included in algorithms for certain groups, for instance, of race, certain neighborhoods, and so on. IA risks also to confirm certain jurisprudence by using IA. So there are risks, but on the other hand, we have to be aware about bias that also without AI, there are important bias in our judgments. And perhaps due to AI, we can reveal more of them and getting a better knowledge of them. So I think to cope with these problems, we must invest in a better knowledge of the conception of algorithms and in the bias that they conclude. Research on this issue must be promoted. EU cooperation is necessary in this field, but also information of lawyers and judges. This must become an important issue, although these risks don't allow us to drop the possible benefits of AI. Thank you.
Thank you very much. Let's move on to Portugal. Mr. Raposo, the floor is yours.
Thank you very much to you all. Good morning here from Lisbon. I thank you. So addressing the progress in European justice in what concerns AI. Well, I would start focusing on the general picture rather in any particular topic or any particular risk. My predecessor already talked about those. So in my opinion, we should start looking at the communication from the Commission from the past December the 2nd. And it gives us a general map of where we stand on, and we can say that somehow the progress in AI in Europe is somehow a bit shy. And in my opinion, I would say that's not a problem. That's a very good standing point. And why is that? Of course, we have developments in the area of anonymization, of speech-to-text conversation, and so on. But it's important for us Europeans to understand that we have to find our own path, our own way forward, rather than focusing on the paths, on the following the footprints that others before us have already taken. And it's at this point, it's important for me to emphasize that predictive justice tools are not the ultimate goal for AI in justice systems. It should be not considered the difference between success and defeat in this area. We have a lot of instruments, a lot of areas in our possible toolbox in AI that can be followed, and it should be followed for us Europeans to understand what is our way forward. So, of course, having said that, I would say that predictive justice tools, of course, will have an important role in the future. No doubt about that. But in my opinion, that will not be the major role of AI in justice systems. And what role will that be, is the question. Well, at this point, I don't want to sound, let's say, too melodramatic, but my belief is that AI in justice will be absolutely crucial for the futures of justice systems. And why is that? And I'll give you just two brief reasons. Main reason number one, and less important than the second, is the efficiency factor. Of course, efficiency is no longer, let's say, a quality assessment feature of the system. Efficiency is really a key element of the rule of law itself. Companies in a European internal market, in a globalized world, in an IT world, will demand the justice systems to answer for their requests. Citizens will also answer for their requests. And if the system is not able to provide them with those answers, people simply will look elsewhere. That's a fact. And if they look elsewhere, the justice system will no longer be nothing but a hollow symbol of the past and will not represent a substantial role in the rule of law and in democracy in our European countries. So that's reason number one, efficiency. Number two, and the more important of all, is that we simply must have AI in justice systems. And that's for a very simple reason. The exponential growth of the amount of data and information that we have in our systems, in our world. That exponential growth of data and information will obviously translate to civil and criminal litigation, and in fact into all litigation forms. only AI will be able to provide us the capacity to reason, to relate, to connect that information. Without it, we are surpassing, if not in some areas already surpassed, let's say complex crime, complex financial crime, for instance, if we have not already surpassed the capacity of human reasoning in dealing with the information. So if we humans want to maintain control of the justice systems, we simply must have this tool of AI tools in our hands. I will later on perhaps tell you about what we're doing in the Supreme Court of Portugal, but now it's important to have really to understand that we must have a toolbox, a toolkit of instruments of AI. This toolbox should be able to be scaled up and shared between European countries, and in the end, this will be our steering wheel to the future. If we don't have these instruments, we may be the drivers, but we won't have a steering wheel to drive our car. Thank you very much.
Thank you very much. Now we heard there may be fields where AI should be used and where AI should not be used. Now, what's the view of the bailiffs on this subject? Mr. Sanino.
Thank you. Good morning, everybody. I hope you are well with this tragic pandemic. Your question, what are the case opportunities and challenges? So, for the profession of judicial officer is concerned, AI represents an opportunity as it is needed to improve the procedure of mass dispute. Of course, in this field, as in any other, there is no question of repressing human intervention by artificial intelligence. On one side, the collection of small debts is an essential issue. For the single payment order procedure, they represent in France nearly 450,000 cases each year, half of which are handled by judicial officers. There is no doubt that the increasing number of these disputes, both national and cross-border, is likely to lead to saturation if we simply deal with them through the courts. On the other side, we must either promote alternative dispute resolution to reduce the number of recourses to a judge, or we must considerably lighten the existing legal procedure to limit the interventions of court and make this procedure more efficient. In this respect, the development of payment order procedure must be considered as a priority. From a legal point of view, this procedure shall be harmonized in all member states so that the use of the European order for payment is no longer limited to cross-border dispute, but is also used for national dispute. At technical level, it is to be considered that a lighter procedure being assisted by an AI, monitoring the conformity of the elements included in the claimant's dossier. Only these cases requiring specific attention will be submitted to the competent judge to be examined. This will greatly simplify the resolution of this procedure, which must be remembered are evident in the most efficient way. Another priority consists in developing alternative methods of dispute resolution to offer a quality service to the party. Such a pacification process is usually considered as a better way to solve most litigation than a trial. If we take the example of mediation, we all know it requires an important investment in human time in order to convince both parties to join, while it is more or less easy to convince the injured party to prefer mediation to judicial process. It is more difficult to convince the opponent. He may be tempted to prefer a trial which is longer and more expensive for the plaintiff. Convincing the recalcitrant party to enter into mediation therefore takes time, which today hinders the development of a coherent economic model. This difficulty could be overcome by an artificial intelligence solution. It is a solution of this type that is currently being developed by the mediation platform managed by the French bailiff within the mediation center called Médicis. The role of the IA would thus to convince the recalcitrant party to enter into mediation so that the mediator can focus on this primary mission, the resolution of the dispute. But these are only a few examples. It is certain that this long-term success of IDR relies on their high performance to find an attractive business model. Of course, this solution implies to scrupulously respect the confidentiality and security standard of GDPR, with which legal practitioners are quite familiar. It also implies to conceive AI as a technical assistant to solution that must be through from a human intervention. There are therefore exciting perspectives for all of us and that bailiff wish to explore with the support of the European Commission. Thank you.
Thank you very much. Well, once again, it's up to the Commissioner to give his comments. And I think, again, there are many topics which could be addressed. And so we are looking forward to your comments on all this.
Yes, I will try to be brief, and certainly because I will have to leave for the meeting, at 12 to go to other kind of discussions on the rule of law. But no, just to say first, thanks for the different remarks. And the first one is about the efficiency. It's true that it's a fact. We need digital tools and we need AI in many different fields, and certainly in the justice system. So there is no doubt about that. But thanks to say that also from the ground, if I may, from different actors, it's very important to repeat that, and to repeat that maybe to the national authorities, and certainly not only for the way to organize investigation, prosecution, or trials, but also mediation and other kind of elements that we have in our toolbox in the functioning of the justice system. And thanks to say that also, that mediation will be maybe a field where it's needed to do the same. The second element is about transparency. It's true that it will be a key word again about the trust that it's very important to develop between the citizens and the different authorities, the different processes, and certainly in the judicial system. And transparency, it's a very important element due to the fact that that it's very difficult to have a real access to the content of different system of using AI, to have a real understanding of the algorithm and so on. So it will be very important to try to ask, I said in my introductory remarks, more documentation and more testing in the way to give a real confidence in the use of AI. But again, it will be on the basis of a risk-based analysis, not only for one sector, but maybe for the different applications, because there are more or less risky applications. But it's true. But I want to add maybe one element, if I may, is the liability. We will discuss maybe also later on this, but the question on liability are becoming more and more relevant, and I said that we'll come with also some proposal next year on this, and it is becoming increasingly difficult for even experts to tell apart real evidence from AI-generated ones, because it's very difficult to understand what are exactly the real responsibilities. And I'm sure that we need to discuss also on this. There's a problem of efficiency, there is a problem of protection of fundamental rights, and a real transparency to build the trust, but there's also a real issue of liability, and not only to organize a process about the liability in the case of use of AI in some products, but also for the different professionals in the justice system to better understand how it will be possible to be confronted with AI in some different cases that they have to take into account in the justice systems. And again, liability will be a quite difficult issue for next year, but it's also an important one if we want to build the trust. And so thanks again for such an opportunity to be with you during 1 hour this morning. I want to thank all the members of the panels. Mrs. Salas Saitamonen is already there, I see, from the DG Justice. So she leads a lot of work in the DG Justice about this very important issue. And so I would like to encourage you to continue the exchange, of course, of ideas, but also maybe of good practices, because it's very important to, to show that there are good and best practices in some member states and in some kind of activities. So thanks again, and I will be pleased, of course, to meet you again physically in one of another opportunities. But I want to conclude thanking again the German presidency, because I know that it was a very difficult, and it is till the end of the year with the Brexit again, a very difficult presidency in difficult circumstances. But thanks for the possibility to organize so many discussions with virtual tools. It's a real evidence that we need digital tools in the near future. Thanks again.
Thank you very much, Commissioner, for this very intense discussion. I think we can be very glad that you are tackling all these questions. Now, thank you very much to all the panelists. And as you all can see, we are running a little bit out of time. But as all the panelists who should have been asked the third question of our first round will come again in our second round, I will close our first session now and move over to our second session on the use of digital tools. And as the Commissioner already mentioned, this second part of our discussion will be hosted by Mrs. Sala Sastamoinen. She's the Acting Director General of the DG Justice, and she will, well, perform the same role as the Commissioner had in the first half of our session today. As I already mentioned, this second half of our event shall focus on the use of AI tools and the areas where it should be used and could be used. And we are looking forward to a first and introductory statement of the Director General to this subject. Director General, the floor is yours. You have to unmute yourself.
I have unmuted. I hope that you have heard me now. Very
perfect.
Okay. Very good. So good afternoon. Oh, actually, yes, good afternoon, 2 minutes past 12. Good afternoon to everybody. And thank you indeed to the Commissioner Reynders and to Dr. Bacher for this introduction. So we are going to the second part. So ladies and gentlemen, I welcome this session, which is now focusing on the use of digital tools, including AI applications. I was listening, you were finishing also reference to the AI. The IT solutions, they have the potential, great potential to support and enhance the access to justice. That way, they are essential for the modern justice, effective justice systems. They can reduce procedural delays, bureaucracy, and costs. Increased availability of the open data produced by the judiciary, for example, the case law, that's also essential for the transparency and is a driver for the European data economy. The European Case Law Identifier, ECLI, is a standard that is a success story and the right step to that direction. The Commission has suggested in its communication on digitalisation of justice to create what is called My e-Justice Space. That would be in the European e-Justice portal. This is a collection of the link to the national electronic services, for example, provision of certified copies of clean criminal record check for use when applying for a job, or statement of marital status, or birth certificate or will. There is work already done in the EU level towards the interconnection on the insolvency and business registers. We are now going towards registering the beneficial owners. The e-CODEX system is the key or building block for the secure electronic data exchange between competent authorities in the context of the EU cross-border judicial cooperation. And we have the first legislation towards that direction. Where to use that one. This is the service of document and taking evidence in the civil matters, but we have to create that system also. So the Commission proposed now on the 2nd of December of a legislative proposal to make a legal basis for the e-CODEX, have it a stable, sustainable development, and then maintenance of that tool later. In addition, there's an increasing relevance to this side of the judicial AI-powered applications. Of particular interest of the field of justice are the anonymization of the court decisions, speech to text conversion and transcription. We use machine translations and chatbots, they called, to support the access to justice and robot process automatization. So despite of the obvious value of such applications they can bring to us, the certain uses of the AI in the field of justice specifically raises legitimate concerns. This is especially for the case of machine learning applications, which would potentially reinforce existing biases. There are also concerns that AI applications could directly or indirectly interfere with the prerogative decision-making role of the judges. So I encourage panelists to share their good experiences, the challenges they have encountered in the digital transformation process. You had so intensive discussions in the previous round, so there was also still the third question about the tools. So we are now also in the tools. So I think that combines well also to this discussion. And with this, without further ado, let me give it back floor to Dr. Bacher for moderating of our discussion. So you're welcome.
Thank you very much. Well, we will enter into this discussion, and the first question will be in what areas, and I think this has already been discussed a little bit, but we want to discuss it in more depth. In what areas do you consider that digital tools could have the greatest possible impact and value when it comes to improving access and improving the effectiveness of justice? Those two issues we have already heard about. We have two panelists which we didn't hear before. The first one is Mr. Panos Alexandris from Greece. He's a lawyer at the Supreme Court of Greece, and since 2019 he's the General Secretary of the Ministry of Justice in Athens. And we welcome Mr. Julien Farobia from France. He's a judge, but at the moment he's the Deputy of the Program Director for Procédure Pénale Numérique. That's a program for the digital criminal procedure, and this program is run in the French Ministry of Justice. Now, welcome to those new panelists, and we will also have two very well-known panelists. It's Mr. Willocks from Belgium, and it's James McGill from Ireland once again. Now, on my list, the order of speakers is a little bit different, but as we have two speakers who weren't on the list so far, my proposal would be let's start with those two new speakers, and that means let's start with Mr. Alexandris in Greece. The floor is yours.
Good morning from Greece, which is also the southeastern border of the European Union. Good morning from Athens. Of course, I didn't have the opportunity in the first questions in order to show and present all the improvements which happened during the COVID period in Greece. Just I have to highlight that inside 6 months, we achieved for the first time in the history of the judicial system in Greece to issue almost 150,000 certificates digitally and deliver them also digitally. And also we achieved to deliver digitally, of course, over 60,000 judgments. This was a great task, and of course, through a very, very difficult coincidence, like it is the pandemic, we achieved to improve very much and develop our task in the digitalization progress. So we can say that digitalization can change the judicial proceedings, either in civil or criminal cases. What is of equal or even greater importance is that digital tools can broaden the access to justice, especially for people who are vulnerable or for persons with disabilities. They can make procedures more easy and less costly for everybody, especially the less privileged ones. In one word, I could say and highlight, as the incoming Portuguese president points out, digital tools can be synonymous of a human-centered e-justice. It's an e-justice which, of course, we need. Another crucial issue is effectiveness of the judicial system. From my experience as Secretary General in the Greek Ministry of Justice, justice digitalization is the only way to have at your disposal the necessary data in order to get in due time effective decisions regarding the administration of the judicial system, for example, allocation of resources. This is also the case for the judicial councils or the judges responsible for the administration of individual courts. Digital tools could provide insight in crucial parameters of the functioning of the courts or even of the performance of individual judges, and thus contribute not only to efficiency, but most significantly also to judicial accountability, which goes hand in hand with judicial independence. I could say with a word, it's a new time, and we should say that we cannot hold back the waves from existing in the sea. We have just to adjust ourselves to it, because we cannot prohibit just progress in justice for existing. And this is a very great task, much more to the countries like Greece, which were not so much developed in the digitalization of justice. Thank you very much.
Thank you very much for this very clear message. Now let's move on to France, to Mr. Farobia.
Hi, good morning from Paris. As far as improving the effectiveness of justice systems is concerned, the French criminal system can provide a feedback regarding the digital criminal procedure, which is procedure pénale numérique, as you said. This program, which started in 2018, will allow digitalizing the whole criminal chain from the filing of claim to the judgment's execution phase. The DCP's goal is to go paperless for all stages of the criminal proceedings. It creates a digital system which is no longer the translation of a paper-based procedure, but a replacement. The entire penal chain is natively or originally digital. The goals of the digital criminal procedure are very simple. The most important is to make criminal justice more efficient. Our philosophy is that digital criminal procedure is not just a technical matter. It is about rethinking the criminal procedure. The digital transformation must simplify the missions of professionals, while ensuring effective respect for the rights of the parties to the procedure, like lawyers, for example. The structural basic principles are two kinds. The first one is to build the digital criminal procedure from already existing electronic systems, which are implemented in the courts and services. These systems will evolve and will be connected in order to facilitate the communication between services, of course. In doing this, we can simplify the tasks of judges and prosecutors through some quick wins. And the second structural principle is to facilitate the access to criminal cases to all the people who are part of it. Victims, indicted people, and those who participate to the criminal cases, lawyers, experts, bailiffs, for example. The thing is that it's very much easier to have access to criminal cases in a digital world rather than in a paper world. Our calendar, our agenda for the procédure pénale numérique is based on an experimental approach on two courts, Amiens and Blois, using the existing informatic tools. It started in 2019. The second step consists in gradually deploying the object's experience. So by the first quarter of 2022, the program will make it possible to digitalize a large and coherent scope of criminal proceedings in 30 countries out of 100. As it was already said by many panelists, with the recent health crisis, the DCP experience in courts appeared to greatly facilitate the work of professionals in the criminal chain. This is how the uses of applications of DCP will individually be deployed at any point on the French territory. For instance, it is the case of a secure tool that makes it possible to deliver any case copy to any lawyer in the French territory, rather than using CD or DVDs. So in the next 18 months, we will therefore digitalize the activity of emergency treatment by the prosecution services with electronic signatures, hearings, and the exchange of procedures with all the actors involved in the criminal chains, for example, court bailiffs. And to finish, because it's the European Union, we have decided to implement e-CODEX protocol and e-evidence application in our system. So as a conclusion, the main thing to remember is that we strongly believe that with the DCP program, the arrival of digital technology in courts should not be synonymous with the complexity and the difficulty of the cultural transition from a paper world to a paperless world. Because our goal is to focus only, on digitalization only when it comes with simplifications for the users and for the people.
Thank you very much. I think I should send some colleagues to France to learn about your your project.
With pleasure.
Thank you very much. So as we are running out of time and as there are two panelists who hadn't the opportunity to give their thoughts so far, my suggestion would be that we end this round of discussion now. So my apologies to the colleagues, to Mr. Willox and to Mr. McGill for dropping you off the list, but I think it's better to have a very broad overview of all the panelists. And therefore, let's close this round of discussion with some final comments given by the Director General on this issue.
Thank you. I thank the panelists indeed on their words. I found it very important that Mr. Alexandris raised the fact that it is about the administration of the courts where the digitalization is also needed. So often when we say that if something raises concerns to AI, it is naturally about the decision making to ensure the human approach and monitoring. The example of the administration of the courts and using even the AI for the efficiency, for the case management allocation, I find that important to keep in mind, because that is this kind of sometimes back office work or the preparatory work that in organizing, that's very important, where we also need this efficiency. So very important point of view. Thank you also to Mr. Farropia for presenting the French part there on the digitalization of criminal justice. Actually, he also brought this, that the case management system has to be functioned so that it takes into account all the parties. So there it doesn't help if the court does internally. It had to have the contacts with the parties, to the lawyers, to the bailiffs, and there comes the creating systems which are interoperable. So our principle of interoperability is also, it is important not only in the cross-border, where we have to have naturally the different countries, but inside, because one has to see the digital criminal justice also as a process, having it really from the beginning to the end. So I found that this is an aspect that we are also trying to bring when we are, for example, thinking how we are developing our normal e-justice, or bringing all the legal professions part of it. So this is some in all the aspects, also in the digital skills, where everybody has to have. And I also make the point about the starting with the pilots. This is what we are doing also in the European level. Like if we take the e-CODEX that was now mentioned, it has been functioning in the smaller group for kind of pilot that we now try to extend, enhance and extend to all on the basis of the, our experiences. So similar, I see the development in France. So as a process, it seems that this is in, well, we know that in the IT system often to go. So sounds good. And I welcome also what was finished there, that stressing the e-signatures and e-CODEX, because this will be the European contribution to the matter. Thank you.
Thank you. Now, as we are supposed to end by 12:30, I think we make one more round of questions, and we have one more question which I would like to address. And I would like to discuss this with the two panelists who hadn't so far the opportunity to give their thoughts. The question will be with regards to cross-border judicial cooperation. How do you think the Commission can practically help member states and legal practitioners? So I think this is a topic which will be extremely interesting to the Director General. And I would like to invite, as I already announced, these two colleagues who hadn't had the opportunity so far to speak to us. The first one is Mrs. Crystal Sitam-Miri from Estonia. She's a prosecutor. She was a prosecutor in Estonia. She is now a European prosecutor, and she is a member of the EPPO Case Management System Working Group. So she should be very familiar with all these aspects. And our second panelist will be Mr. Stefano Opilio from Italy. He's the Director General of the Directorate of International Affairs and Judicial Cooperation at the Italian Ministry of Justice. Now, where should the European Commission help, and how could it best help member states and practitioners? Ms. Sitam-Miri.
Thank you very much for the introduction, and good afternoon from Luxembourg. I think that when we're talking about digitalization, then the main challenge actually in cross-border judicial cooperation is that member states are on a very different level when talking about digitalization. Here in the European Public Prosecutor's Office, we're currently preparing for starting our operational work next year. And of course, it's very clear that the functional case management system allowing us to change information between 22 member states and with the central office is one of the absolute prerequisites, since we cannot, of course, imagine truckloads of case files being transported between 22 capitals and Luxembourg. And while developing our case management system, we have also seen that while we are talking about digital procedure, we actually talk in very different languages. And I don't mean, of course, English or German or French here. But just to give you an example, then, for some member states, digitalization means scanned PDF documents. For the others, it can mean sending a memory stick with the information between authorities to exchange the information on it. Or for the third one, it can be even talking about metadata and use of artificial intelligence. So this is what I wanted to emphasize, that we are on a very different level in different member states. And coming to the judicial cooperation, I think the recent digital criminal justice study actually pointed out the main needs in the criminal justice domain, and especially in the cross-border judicial cooperation. Since we probably don't have time for those details today, I would like to make maybe a more general point or observation here, which in my view could also help. I think it is very crucial that the legal framework has to support digital proceedings, and not only on a national level but also on EU level, because we all know that the procedural law in member states on a national level, and also most of the EU legislation, is actually coming from so-called paper era. So it's not adjusted for digital procedure. And I think that that from legal point of view, it is very important that all the legal acts, that in all legal acts, the idea or the purpose of digitalization is always kind of in the back of our head, so that all future legal acts also on the EU level are promoting digitalization, and at the same time that they are technology neutral, because we know that technology is developing very, very fast. And we shouldn't put ourselves into corner to fix something very strictly in the law, and then while the IT technology develops, then we have nothing else to do anymore. And we also have to keep in mind that that the EU legislation could be kind of a push for those member states who need it, and at the same time, it shouldn't be like pulling back those member states who are maybe a little bit more advanced in the digital field. And I was actually very happy to hear from the commissioner this morning also that he also found that the legal acts in EU could benefit of a relevant upgrade regarding digitalization, and that the default communication channel should be actually digital when we're talking about digital or judicial cooperation between different member states. And of course, we have to keep in mind that we cannot digitalize international cooperation if member states are not digitalized on a national level. Of course, this is a question of resources, question of money, of human resources, and hopefully the new MFF will help here also. But I think we cannot forget the legal side also. Thank you very much.
Thank you very much. And now let's move on to Rome, to Mr. Ocasio. The floor is yours.
Thank you very much, Mr. Chair, for giving me the floor. Good morning from Rome. I will keep my intervention rather short due to the time allotted to me. So the question is how to further improve cross-border judicial cooperation between competent authorities. And I would start focusing on the priorities. First priority, in my opinion, is the improvement of information exchange, especially in criminal investigation and proceeding across the EU. No need to spend too many words. Cooperation and information sharing are the most powerful tools to combat crime. We have important EU instruments such as the Schengen information systems. We have new EU level databases for security and border management, but this is still not enough. Much information is still located in national databases. Some interconnections between investigation or prosecution authorities are lacking, and the result is a significant additional workload, delays, and increased risk that key information is missing. So we need first of all, to create a unique communication channel to communicate with all relevant stakeholders. The information is often exchanged between the different stakeholders, I mean police, practitioners, central authorities, agencies, Eurojust, EJN, via different channels. And confidential documents are sent via post, and we don't have a technical solution allowing the investigators to send or receive large data files in an electronic and secure way. A need for a communication channel to reach out the different stakeholders. A need for a communication channel to exchange data in different format and in large volumes. Need to send and receive information, sensitive, confidential, via a secure channel from all stakeholders involved in the cross-border case. And this should also include the setup of a secure channel for communication among the EJN and authorities to make possible the flow of data and of requests for judicial cooperation, at least between member states, as we all know that EJN is a very important and daily used hub for judicial cooperation. Need to be able to cross-check against the data in the Eurojust case management system, the TTO case management system, Europol, Schengen information system to identify links between cases. This is a need indicated by all stakeholders. They need to enhance it-know-it connection between the main stakeholders and in particular between Eurojust, Europol and the EPPO's case management system. That's very important because a major concern with the practitioners is that they don't have technical means to verify whether the crime suspects they are prosecuting have links in criminal proceedings in other countries. There is no systematic way to check whether investigators in other agencies, countries are working on related cases, and this is anachronistic. There is a need to modernize Eurojust case management system. Also, the link between Eurojust case management system and national databases is crucial. The setup of a new digital exchange system, of a secure platform to transmit European investigation orders, mutual legal assistance requests. This means also initiative, legislative initiatives, and the e-CODEX in this sense is vital, is very, very important. We have to support this, this proposal. Consideration might well be given to setting up a digital platform for joint investigation teams. This is very important because, in my opinion, among the many reforms taking place in the last 20 years approximately at international level in the field of judicial cooperation, joint investigation teams are the most innovative tool. They have a large potentially still unexplored, and the joint investigation teams have many practical advantages. And there is, and I'm concluding my intervention, there is a need of investments and training. Training is really very important because sometimes, as we know, only judges can telework and court staff members are not able to fulfill their duties and work securely remotely. And in these conditions, even smart working risks leading to a slowdown in production activities and producing inefficiency. So we have to ensure that practitioners, lawyers, officials, employees, judges and prosecutors can better adapt to new technology, particularly by having access to new tools and acquiring new skills. Thank you very much.
Thank you very much. Now, there are a lot of challenges, but maybe also a lot of chances which we can take. So we are very much looking forward to the comments given by the Director General and perhaps also some kind of closing remarks given by the Director General. Please.
Thank you very much, and thank you again to this panel. I would, so how can Commission help? I saw indeed the mentioning the challenges. So thank you to Mrs. Sita Mnyri, who was raising the aspect of the, you mentioned as languages. It means that we are in the member states are different level. How can Commission help? One element has been that we have then, for example, we have taken the task to prepare a model system or reference system. This was something that we were doing for the e-evidence file, or we are doing for the service of documents taking evidence in civil side. So this type of reference system is an example when the member states which are on the different level can join, it increases it to some and gives already then ready-made solution to the others who are further. So one example, but we take this point that it is an issue that we need to tackle. Also the point about the legal acts that in the we are moving to the culture where, or also in the justice area, the digital is indeed by default. So we are building it on that basis, and then it applies on the so that when we say that the means of keeping the data often is then by starting point electronic means how we keep the data. So that point taken, and indeed there, as the Commissioner has announced, we will come with a proposal that would make it by default in the European procedures. And when it comes, what we have learned that when we do it in the European procedures, it is indeed a incentive for the member states to follow also on the national level. We know that from the areas where we are not directly legislating in the national procedures, but where there has been an impact. So we hope that also applies in this case when we are making for the digital by default system. To Mr. Opilio, thank you also for making you raised the link of the security, how to have this type of the connectivity where these connections are secure. So we take that point. We are one aspect that in general, also with the Digital Europe funding program, we are bringing to the connectivity more funds that should allow more, let's say, powerful connections, which actually allow them more secure connections. So I take this point that the security would be there, because that is also, well, that helps then linking the case management system or the cases. We are aware of the modernization needs, for example, for the Eurojust, and we are trying to find their solution and help. It means in practice budgetary help. What is needed, and all this linking. Naturally, we have to take into account also that our data protection rules are then such that that they are supporting also in the judicial area this type of the linking and access to the sufficient information. So I'm taking also this point with me to have there the sufficient guidance. And I'm happy that Mr. Opilia finished with the training, because as well for so many of us, this time when we have to learn all these various means of having the web conferences, it means the new skills, new training. So that is certainly with our new strategy, one point of the priority is the training on the digital skills, also in dealing with the criminal justice cases. So indeed, Dr. Wache, thank you very much. You already invited me then for a finishing words. It will be very short finishing words. I would really much like to thank the presidency for this event, making it together with us. I would like to thank the moderator who have done a great job. I mean, there's always so much information and material. You have kept us well in time. Thank you to all the panelists for your participation, for your very focused remarks. We are really taking these with us. It is the time of the consultations to do then something new, and there we need this wisdom of everybody. So thank you to all the panelists. So let me finish really by wishing you a very nice festive season, holiday season. We are on the last events now on this before the Christmas. We have last events of the German presidency that I really congratulate for a successful presidency so far. So let's be also successful in the future. Next year then delivering this justice that is digitalized. That will be our task. Thank you.
Oh, thank you very much, Director General, and thank you very much also from my side to all the panelists. I think we could have discussed all day and it would have been worthwhile, but I think we had an excellent overview over all the possible problems and on the possible chances. And well, it was said the most important thing is communication. We have been, well, starting a communication process, and I think we should continue it. And I look forward to more discussions on this subject, be it virtually or be it in nice places in Brussels or anywhere in Europe. So also from my side, have a very, very good holiday season, and let's all hope that all the things we have had to learn in 2020 will be over sometime in 2021 and will not return too soon. Happy Christmas to everyone and goodbye.